Hi, everyone. Thank you for joining today's webinar presentation, Drafting Quality Patent Applications, Nautilus, Means Plus Function, and Other 112 Matters. I am Gail Martin, Associate Marketing Manager at LexisNexis IP, and I want to cover a couple of things before we get started. Please feel free to submit questions during the conference by using the chat or Q&A feature. We will be sending you a copy of the slides and a link to the recording from today's presentation. Now I'd like to introduce today's presenters. Jean Quinn. Jean is the founder of IPWatchdog.com, a patent attorney, law professor, and leading commentator on patent law and innovation policy. Jean was recently named one of the world's leading IP strategists by IAM for the second consecutive year. Joseph Root. Joseph is the founder of Qualipat and has served as both IP and general counsel, in-house and out, for corporations and law firms in a career spanning 3 decades. In 2008, he founded Qualipat, a company performing IP services and training. He is also the author of Rules of Patent Drafting, Guidelines from Federal Circuit Case Law. Thank you again, everyone, for attending today's presentation, and with that, I will turn it over to you, Gene.
Thanks, Gail, and thank you, everybody, for being here with us today. We really appreciate you taking a portion of your day to join us, and we obviously had a really big turnout for this event. So we've hit a real sensitive subject, which, you know, it probably shouldn't be, but it seems to be a moving target and one that is all too important, and we'll talk about that as we move through the webinar here today. And excuse me, and we have with us Joe Root, as Gail mentioned, and Joe has written a book on patent claim drafting and drafting patents in general. So I'd like to get his take on it, and this is what we're going to talk about, and you all already seen this, so I'm not going to dwell on it, but we'll stop here as I bring Joe into the conversation. Joe, I'd like to get your preliminary thoughts on what we're going to talk about here today, setting the table. It feels to me that we almost have this moving target that we have to hit. And, you know, we're writing these applications today, and then by the time they are valuable and getting litigated or licensed, the target is moved. And, I mean, I guess that's just the new reality in some respects. And, you know, I'm almost speechless. I don't know what to say, and it just makes it very tough for anybody who's trying to draft applications, I guess.
It does. I mean, basically, the way things work, we've got to have a crystal ball that is going to show us what the patent law is going to be 15 years down the road, because that's how long it's going to be before, you know, between the time that you file a patent application, then you've got several years back and forth with the examiners, and then time goes by. And what is the law going to be like by the time that you get to the point of litigation? And that's an impossible thing to predict. And what that calls for is a lot of care in drafting every phase of the application, because as you know, the basic thesis of my book is that patent law has shifted its focus from being strictly oriented on claims, as it was when back in the day when I was learning this craft, and has shifted to more of a focus on the specification. Now, that's an important shift, and there are a lot of cases out there where the specification wasn't drafted with a lot of the same care that we give it today, and yet that's the law that's being applied. What's the situation going to be 15 years from now? You know, I don't have any idea, and probably you don't either. The only solution to that is that we've got to write the best possible application all the way across the board. We've got to pay attention to the specification. We've got to pay attention to how much detail we go into in description. We've got to show a lot of different applications of the of the invention and a lot of alternatives and variations. All you can do is try to give it the broadest scope that you can and do the best job that you can.
Yeah, you know, and that's the thing. I mean, there are no crystal balls here, and but you almost need one. And I mean, I agree with you. I think that, and this is something I say all the time, you know, and it is what it is. Clients, to a large extent, unfortunately, are going to get the patents that they're willing to pay for, because with every new case, it seems that the courts want more and more and more, and the only way that you can get that more is, unfortunately, by spending more time. Now, there's tools that are out there that can help streamline some of this, you know, and make sure that you're not making silly mistakes, and we'll talk about some of those. But I think that's probably a good place to jump off here and move forward with the outline, because, Joe, we wanted to talk about, one of the things we want to talk about are these types of indefiniteness situations that can arise, so that we're sort of setting the table about what it is that we're talking about here. So you want to take this? Sure.
Basically, when you talk about indefiniteness and definiteness, there are three basic slots that all of these situations fall into. One of these you can call conventional definiteness problems, and that's the issue where you're looking at the basic understanding of a claim. And there we're going to talk about the recent Nautilus decision. A second type is where you simply make a mistake in a reference or a mistake in an area. And that can fall into a technical error field, such as antecedent basis and that sort of thing. Or I've seen cases where basically you've got a lot of numbers and calculations and they don't work. That's a problem of definiteness. Or a matter of grammar, because there are cases out there where grammar winds up affecting meaning. A third type is the means plus function claiming, and we're going to talk about that in a bit of detail. And the question there is whether you have adequately identified a means plus function claim or a portion of a claim, and then have you given the right sort of device that performs the function. Here we're only going to be talking about one of those. Mm-hmm. Want to bounce that slide, Gene?
Yep. Let's move to the next slide. Go ahead.
So basically here we're only going to try to cover two of those areas today, time being limited. We're going to talk about the conventional sort of definiteness problems as exemplified in the Nautilus decision, and a couple that have come after that, illustrating where that's going. And then means plus function claiming, where we're going to focus on the Williamson against Citrix case. So we're going to start with conventional, and Gene, you want to talk a bit about the Nautilus decision?
Yeah, and I think we have that here in the next slide, right? Oh no, the next slide we have is another slide to kind of set the table here before we get to Nautilus. And this is something that, you know, over the years, we've had occasion to, and we've all had probably this occasion to talk to examiners periodically, and they'll tell us various things. And you know, I always try and ask them is like, you know, if you could talk to a bunch of attorneys, what would you tell them? You know, and they obviously know why I'm asking that question, because I'm going to take what they tell me anonymously, of course, not to embarrass the examiner or to get them in trouble or anything like that, because we want to know what they want, right? I mean, because if we can give them what they want, we're obviously going to be helping our clients. And over and over and over and over again, the very first thing that I hear from examiners deals with 112. And the reality is that the same type of time constraints that we have as patent attorneys, that, you know, it's maybe not the same type. I mean, because clients for us are wanting more and more for less and less, and we got to do bigger patent applications, and they want to pay less by the hour and all that sort of thing. So that's our time constraints. The examiner's time constraints is they're getting these bigger applications that we're doing, longer applications, more detailed specifications, more prior art that is all the more detailed because of previous said reasons, because of all the court decisions that are requiring this. And they only get, 12, 15 hours, maybe in a highly complicated area where you're thinking about NASA sending something to Mars. Maybe they're going to get 30 hours, start to finish in a technology like that. So if you understand the examiner's strains, and they're also time constrained in these cases, then you can help your client. So when the examiner's time constrained and they have to spend a lot of time on the front end with 112 rejections and going through the applications, and before they can ever even get to 102 and 103, they get frustrated and upset, and it slows things down, and it really just causes prosecution to come to a grinding halt. Now, a lot of that, unfortunately, and you look at the last one, is here it says, please check and correct any foreign translations. Now, that's not a problem that we can sometimes do anything about, right? Because the clients are going to give us these translations, or they're going to prevent us from fixing the translations, or they're going to prevent us from fixing the claims at filing because they don't know whether they're actually going to go through with prosecution. So the claims that are filed are a literal translation of whatever was filed overseas, So a lot of this stuff is just mindless nonsense that the examiners are getting. To the extent that you can fix that in any of these cases, do that, because it wastes time and it's just throwing away an office action. Joe, do you have any thoughts about this?
Yeah, I agree. I mean, basically, being careful with terminology. Always make sure, and this is something that you can check, and I think they're going to talk later about the Patent Optimizer tool, but there are ways, there are computerized tools to help you check consistency. And if you can make sure that you are calling a widget every single time, all the way through your specification and into the claims, that's going to get you off in the right foot. Additionally, I'd like to address a quick point here, because there's been a question raised that's a bit off topic. Let me just address it very closely. We were asked about one of you noted that that we're always cost constrained in everything we do, and asking if there's any cost efficient implementing strategies for practitioners. And as I said, that's a bit off topic here, but I would indulge in one bit of shameless self-promotion. In my book, I talk about the problem of what happens when you would very much like to have multiple embodiments. A lot of folks will tell you that you're practically committing malpractice if you submit a patent application with only one embodiment, but sometimes that's all you've got. And the way to get around that is to use alternatives and variations, and I talk about that in the book in a bit of detail. So I would, as I say, do one quick bit of shameless self-promotion, and then move along, and then let's talk specifically for a bit about definiteness.
Yeah, no, and that's fine, because I wouldn't call that so much shameless self-promotion, because hopefully everybody knows LexisNexis has been a great sponsor for a very long time of IP Watchdog, and they are sponsoring this webinar, and they do publish your book. And
they do.
And also,
very
they do. And and it is a good book, and by the way, I've been traveling so much, I don't know whether I've gotten a copy of it yet, but I have the older version of it, and it's a great book. But the tool, and we have a slide coming up at the end. I put these out of order. I apologize, but it probably would have been better to put it right here as we were talking about these simple fixes. But, LexisNexis does have a tool that helps you review the applications that you file to make sure that you're using consistent language, to make sure that everything that is in the claims has support in the specification. So rather than having to go through and wonder or having a human check this, it's computerized. And they also check the drawings and make sure everything in the drawings is discussed in the text. All the numbers match up, and everything that is called out in the drawings is actually referred to in the text. And, you know, it's really cool, and it's very cool. I'm a geek. I really think it's cool. And it's not only is it cool, it is really helpful. And it addresses this problem exactly. And it does kind of streamline this process to make sure that you're getting over the 112. Now, is that cost saving? Yes, it is. And the problem with explaining how this is cost saving sometimes is difficult, right? Because it's the cost you're not going to incur that it saves. And this slide explains why. Because examiners only have, we all know, a finite amount of time to look at these actions. If they're going to have to spend a ton of time on 112 issues in the first action, they have just wasted almost all of the time that they have available in the case. And guaranteeing you that you're going to have to file at least one RCE in order to get that case allowed. So that's going to increase the cost. So if you can push through and have a solution to make sure that there are no 112 or very few 112 issues in the applications you file, that is a strategy to getting to a positive resolution much quicker for the clients. So something to think about. All right, now I think the next slide, Joe, I think that's when we start to get into the Nautilus decision. So first we have here just the statute to give everybody, you know, the recollection. The statute here is 112B. The specification shall conclude with one or more claims, particularly pointing out and distinctly claiming the subject matter. So very simple, and then that leads us to Nautilus and the Nautilus surfaces. Now that's I think that comes straight from your book, right? Do you want to take the lead on this?
Sure. And let me note, the statute, this is one of the statutes that did not change with the AIA. So you can look back, and the cases going back on the statute are going to be valid. There's nothing that's been superseded by the AIA change in statutes. So basically what we've got is a situation where for quite some time the Federal Circuit had followed a very patent drafter-friendly standard that in order for something to be called indefinite, the claim had to be insolubly ambiguous. And what they said was that as long as somebody can, no matter how hard they have to work, as long as someone can sit down and construe the claim, then it is definite. As you can guess, there were very few cases were thrown out under definiteness under that standard. So this went to this case went up to the Supreme Court. There's a case based on Nautilus exercise machines. And to get to the Supreme Court, and the Supreme Court basically, as they have done on a number of, has been a number of cases, they have beat the living bejesus out of the Federal Circuit. I mean, they basically said that the Federal Circuit had just completely followed the wrong standard. And what they said was that that here what you needed to do, and the important words are in the quote right there, viewed in the light of the specification and prosecution history, the claim has to inform those skilled in the art about the scope of the invention with reasonable certainty. So the key words there are reasonable certainty. So the Supreme Court there beat the Federal Circuit about the head and shoulders, sent the case back down for remand, and guess what? They looked at it and said, you know, we're very glad to have the Supreme Court's guidance here. We thank you very much, but it's still not ambiguous. So basically, my take is that meet the new boss, same as the old boss.
Yeah, you know, and they do that. They do that a lot. They did that with KSR too, you know, and and I don't know how they managed to do that with KSR, because KSR totally changed, you know, everything. I mean, before KSR, obvious to try was simply not a acceptable rationale to reject, and yet case after case you read in obviousness, and the Federal Circuit says, oh, our old obviousness cases are completely fine. They're not overruled by KSR. And it's like, how do you get from there to there? You know, and I guess, you know, to some extent you can sort of understand it in a way, you know, because they've got this case law that they want to try and salvage some of it, or as much of it as they can, so they don't start from scratch. But the insolubly ambiguous test is just, well, for lack of a better way to describe it, was insolubly ambiguous itself, you know, and patent law throughout everywhere is always about what one of skill in the art would understand. So you know, I'm not a fan of the Supreme Court, and everybody probably knows that, but I think that they probably got Nautilus correct. And I don't know what's going on with the Federal Circuit sometimes, and but it seems like I just don't know. Sometimes I scratch my head. Are you doing the same thing, Joe?
Oh yeah, I mean, and basically here, I think for a change, because I agree, a problem with the Supreme Court is that the Supreme Court hates bright line tests. The good thing about the Federal Circuit is that they are trying to give lawyers tools that the lawyers can then use to make sure that they can advise clients. I mean, the client comes in and the client doesn't want to hear that, well, you know, this is going to make a very interesting appeal. Right. The client wants to know whether that this claim language is going to work or it's not going to work. And
right, but do you think the insolubly ambiguous test did that? I mean, I always thought that was like the height of uncertainty, you know?
Well, it is, but in the way it was applied, I mean, the trouble was that the cases that got thrown out really were insolubly ambiguous. And it had, for example, we mentioned in a couple of slides here the data mines case.
Yeah. Well,
you know, I think the good news is that the standard, I don't think the real standard changed at all. I think the same set of, if you take the set of cases that everybody would agree and all the courts would agree are indefinite under the old standard, I think that carries right through to the new standard, truth to be told.
Yeah. Yeah. Okay. So prosecution versus litigation, and I know we got a few slides on this because it gets handled very differently.
Yeah, and this is one that as prosecutors we've got to be very careful of, because you've got, on one hand, you've got the standard that you see courts set out during litigation, and there the court is going to construe a claim to preserve validity, and they're going to read claims narrowly. So if there are two plausible claim constructions, the court is going to pick the one that leaves the claim valid. Now look at what happens to us during prosecution. Go hit that one, Gene.
Yep.
And there, the task here is that the examiner tries to do is identify all possible ambiguity, and so there you give claims the broadest reasonable interpretation. And I'm sure that this is a standard that, if you're a prosecutor, this has driven you crazy on a regular basis, because you know what you're talking about, and the examiner comes out with a reference completely out of left field. I mean, I was doing, once I did an application that was involved with processing chocolate chip cookies, and it was in an extruder. and the cited reference was for the extrusion of napalm. So I successfully argued that napalm is not really like chocolate chip cookies, and this was not a reasonable interpretation. But you've got to work at that. The philosophy is that because you've got the opportunity to go back and revise your claim language, then the examiner's job is to construe the claim extremely broadly. So we've got to, that's when you're drafting an application, you've got to be thinking about broadest reasonable interpretation, because you got to survive examination to get the litigation.
Right, right. And on top of that, I have a slide that I added here about relational language, which may be a little bit out of order, because I think we wanted to, maybe we can come back to that slide if we have time. But the slide here is the slide that should have come next. Is ex parte McWard, because on top of the differences you just mentioned, it's also important for everybody to understand, particularly prosecutors, that the Patent Office does not follow Nautilus even. They follow In re Packard. And this is a precedential decision from the PTAB from August 2017. And now this may change as Director Iancu is going through and looking at things at the board, because what happened was there was a case that we'll talk about here in a minute, the bunch of balloons case that went up to the Federal Circuit, and the office filed a brief on behalf of the alleged infringer to intervene. And one of the things that the Patent Office argued in the brief was that they were able to not follow the Nautilus standard, among other things. And then when Director Iancu became director, he filed a motion to withdraw that brief because they were doing a front-to-back review of everything PTAB. So he didn't want to be on the record as having that be the Patent Office position on anything as this review is going down, because that may not ultimately be where they wind up landing. So the Federal Circuit did allow the Patent Office to withdraw that brief, and that case has now been decided. We'll talk about that in a minute. But currently, the Patent Office does not follow the Nautilus decision. And the rationale here is that they don't think and the Nautilus was about a litigation between two parties, and they don't believe that anything in the Nautilus decision requires them to, when they're examining an application, use that particular standard. So I find it a little bit difficult to believe that the last pronouncement on indefiniteness, excuse me, which uses the very familiar one of skilled in the art, which is just permeates all of patent law in every avenue. That's what 112 is all about. That's what obviousness is about. That's what, all of this stuff is about, what one of skill in the art would understand and believe and think. And yet they're not following it. So I have a trouble wrapping my head around that, and it seems a little bit disingenuous to me, but maybe that's me. Joe, your thoughts?
I think, yeah, I agree that basically here, you've got to, during prosecution, you've got to be looking at the way the examiners are going to apply the rules and what is going to happen in the PTAB, because that's what we've got to solve. And they don't really, citing Supreme Court decisions to examiners doesn't really get you very far. One of the most valuable things I learned very early on was that if you're going to cite something in an argument or in a PTAB brief, you are much better off citing the NPEP than you are citing the Supreme Court.
Yeah, absolutely. That's absolutely correct. Now, but if you look at the very bottom of this particular slide, the Packard language is that a claim is indefinite when it contains words or phrases whose meaning is unclear. And then put in a different way, claims are required to be cast in clear as opposed to ambiguous, vague, indefinite terms. So I suppose what they're trying to say is it has to be as clear as possible. Now, this gets into some kinds of, real problems because, there are cases out there that talk about it's not the examiner who gets to choose the words that are being used. The fact that the examiner believes there are better words or terms or ways to say it isn't the question. So to some extent, I think the Packard decision allows a certain mischief that the Nautilus decision does not allow for. Because with the Nautilus decision, if you were to get into some kind of situation where the examiner was really being, let's say, what you believe to be unreasonable over certain language in saying that language is unclear, I don't get it, I don't understand it. Well, it's not the standard that you don't get it. The standard is whether people of skill in the art don't get it. And here, I can prove to you that they do get it, that they do understand it. That's a much more, I think, objective standard. And maybe it doesn't matter in a ton of cases, but, we have seen those cases, Joe, where examiners do really put their foot down and think that there's a better way to say it and do it, and that's not what the rules are supposed to allow.
That's not, that's right. But the examiner is the examiner, and if we've all had cases where you really believe that the examiner is completely wrong, and yet it goes through, and next thing you know, your client is put to the cost of filing an appeal to justify that, or at the very least another round of prosecution with an RCE. Yeah.
So, all right. Well, maybe this is one of those things that it doesn't matter most of the time, and it won't matter until you get in a case where it does matter. So just kind of file it in the back of your brain for right now that as of right now, they don't follow the Nautilus decision, which I know in talking to some practitioners has come as a surprise once they get that thrown at them by an examiner. All right. Now the bunch of balloons case. So the balloons at the CIFC. Now I like this case, one, because it's easy for everybody to understand what it is, and two, I'm friends with the inventor, so I've become friends with him over the last handful of years. So this is a really interesting case to me, and it also deals with language substantially in the application that is, or in the claims that is language that are in tens of thousands, if not hundreds of thousands of patents. And it was argued that the substantially filled was indefinite. And the PTAB bought that argument, believe it or not. And the Federal Circuit did not. Now, this case also had a very interesting twist to it because one of the reasons that the Telebrands argued that substantially filled was indefinite and inappropriate in the claims was because the term substantially filled was not actually in the specification. Now, this was not a problem created by the attorney. This was a problem that was created by the examiner because the examiner suggested that language be added to the claims in an examiner amendment, and if that was added to the claims, the examiner would allow the claim. So the examiner is the one who introduced that to the claims and explained in the reasons for allowance why by adding that would overcome his problems with certain other prior art. Joe, real interesting procedural aspects here.
Yeah, it is, and so there's one that you can probably get through the. You can probably get that examiner, but then you wind up down the line, and you hope that somebody is going to see that if the office is saying this through the mouth of the examiner, then they ought to accept it. That takes you one way that I have seen some success at working with some times where an examiner is objecting to a particular set of language that you think is used all the time, is literally to go back and look over the last year and see how many claims, how many patents issued with claims having that, the language substantially filled. And if it's a pretty good chunk, I have argued that this is clearly definite, and you can see it by the fact that this many patents issued with that term, and I think that that has turned out to be a fairly successful and effective line of argument.
Yeah, and now this case, the Phineas is the name of the company, and they're the ones who own the patents on the bunch of balloons, which is the water balloon invention. If you're unfamiliar with it, it's the best-selling toy in the world during the months where it is warm. And if you remember Costco, every Costco I've been into, it's the first product they have right at the very front of the door during the warm weather months. And what you do is you hook up your hose to it, and it will fill up 100 water balloons in 60 seconds. And when the balloon is full, it falls off. So the whole question here is it will fall off when it is substantially filled. And this case has gone up to the Federal Circuit a couple times, one on a preliminary injunction. And at that point, the question again was, is substantially filled indefinite? And I believe it was Judge Moore in that decision said that she was not about to say substantially is indefinite because there are literally tens of thousands of patents at a minimum that use that word. And it is a word that every patent attorney that practices understands what it means. And particularly in this context, where the specification gives ample explanation of the invention and what is going on, and when the balloon is filled enough, it falls off. So that means if the balloon is not filled enough, it doesn't fall off. So the fact that the examiner introduced this language was not crippling at all because the specification defined the invention. Now, if you're doing this in the first instance, you would not want to do that. If you were going to write that substantially filled into the claim, you would want to have substantially filled in the spec. Thoughts on that, Joe? Yeah, absolutely. And, actually, and this takes us to what I think is the most important point about definiteness, and a very clever member of the studio audience here has raised that as a question, and that is the relationship between the specification and the claims. Yes.
As I mentioned earlier that basically the reason that I wrote my book was to argue that today the specification is of prime importance. In fact, I argue that today we live in a WYSIWYG world. WYSIWYG being what you disclose is what you get. And the trick there is to explain in the specification using language that you then repeat in the claims, so that indeed you can go back and say, here is what this term means, because the specification has either defined it expressly or has explained it so that a person of ordinary skill in the art would have no questions about what it means. And I think that's well illustrated in the two cases that come up next here in the batting order.
Yeah, and what I would just say for that question, and also I asked, are they not interpreting the claims in light of the specification? And unfortunately, examiners don't have time to read the specification, but that doesn't, and I think what that has historically meant is people have skimped on the specification. The fact that examiners do not read the specification cannot mean you skimp on the specification, because we are in a world where the specification is the king. Yes, the claims are as Judge Rich said, the claims are the game, the name of the game, or something like that he called it, you know. But the specification is the king, because that is where you define the invention, and that is where all the terms are that you're going to use in the spec, and judges are looking at the spec to see whether these terms are explained, whether they have meaning, whether the invention is there, whether there is a there there. So you have to have a good spec. And
that's right.
All right, so here's the datamized case, and the old rule: the scope of the claim language cannot depend solely on the unrestrained subjective opinion of a particular individual. So that was datamized from 2005. And then we get to the new rule, and this is a great case. Do you want to tell us about this one, Joe?
Sure, because the datamized case dealt with a computer interface that had to be aesthetically pleasing. That was the language of the claim. So what in the world does aesthetically pleasing mean? Well, that's going to vary with every viewer, and so that got thrown out. That was insolubly ambiguous.
Right.
So along comes the Sonics case, and here you've got a graphical indicator applied to the surface of an object, so that you can so that a scanning device can read something off of this visual indicator, but it's got to be sufficiently small that a viewer is not going to notice it. It's got to be visually negligible. Take that down.
I'm trying here. There we go.
So that's fine. There we go. So there's the claim language. You've got a processing system comprising an optical device for capturing image from a selected zone on the surface of an object by a user, wherein the object includes a graphical indicator that is visually negligible and is affixed on the surface of the object. So the examiner says visually negligible looks exactly like aesthetically pleasing. But look at the specification. Because here you've got, if you go back into the specification, you find first the drafter set out a general exemplary design for a visually negligible indicator. So what does he mean by one of these things? Here's an example. Then he says that here's the way that you can make such a device visually negligible. What are the requirements for that? What are the meets and bounds for what I mean by visually negligible? And then how do you do it? And then here's two specific examples fully explained. And so when the court looks at those, when the court looks at that specification, there is no question whatsoever that a person with ordinary skill in the art cannot go to that specification and come out the other side with a visually negligible graphical indicator. So then that is completely definite.
And this, Joe, is why I get so upset when I hear people say, oh, yeah, it's black letter law. You can't read into the claims from the specification. And it's, I just want to, like, slap them when I hear that. It's like, no, that's actually wrong. That's not black letter law. As a matter of fact, the black letter law is exactly the opposite. You specifically and intentionally can read into the claims from the specification. That's what we just did here. That's what we just saw here. That's the entire point of the specification. What you can't do is you can't impermissibly read into the claims from the specification. So what people miss, and this is something that I think litigators miss a lot, is the word impermissibly. And if there's a hook in your claim, the way I always try and describe it to the people, I'm doing this now patent training for newbies, for patent agents and attorneys that have a couple years of experience. And the way I explain to them is, like, you have to have that hook in the claim. If you have a hook in the claim that has the term, then you can go back into the specification and say, okay, well, where's the term? How have I described it? Is the technology full? visually negligible is the perfect example. What does it mean? Does it have a concrete, definite meaning? And in this case, it did. So that's exactly what they're doing. That's why you need the spec. So even though the examiners are not going to really read the spec, not really, they're not going to read the spec. They're not going to sit down and read the spec from front to back. That's one of the reasons why you should be doing and taking part of these interview programs before first action, because it's a perfect opportunity to, in an hour, talk to the examiner about the invention and bring them up to speed, because they're not going to read the spec. But you have that opportunity, and they have the time, so you can inform them of what they need to know. And then you use those definitions and descriptions and thick technological, almost manual-like descriptions in your specification get imported into the claims. And that's what we do. That's what you have to do today. And that's why, you know, and Joe, when we first reached out to you, you were calling this how did you call it, the disclosure revolution. When I heard you use those words, that's when I reached out to you. I'm like, oh my God, we're on the same page here.
Yeah, because that, you know, that also makes for a very straightforward and inexpensive to your client sort of office action. Because then the office action is you don't have to make a long argument. What you do is say, here's the portion of the specification that explains this term. You cut and paste out of the specification. End of story. And that, you know, that completely establishes the fact that you have shown how this, you've taught a person of ordinary skill in the art how to do this, and so that there's no question about it.
Yeah. All right. Well, looking at the time, we need to move on to the means plus function goal. At least talk about that for a little bit. And here's the statute 112F. You can use means language instead of structural support. And the case that is most important is Williamson. We have just some basic statements here. If the claim recites a term associated with function, the examiner should determine whether the claim invokes 112F. It is presumed to invoke 112F when it explicitly uses means for or step for. The presumption is overcome when there is further structure that is recited. By contrast, a claim limitation that does not use the phrase means for or step for will trigger a rebuttable presumption that 112F does not apply, and that is a strong presumption, but it is still only a presumption. And that brings us to Williamson, and this is what changed things and kind of surprised and maybe even scared a number of people, Joe, back now 3 years ago.
Yeah, that's Williamson. Let me back up a bit. I think means plus function claiming in general has gotten an unfortunately bad press.
I would agree.
Because they can be extremely valuable. The trick is that you've got to simply know how to do it, and knowing how to do it is actually not that hard. I mean, when you want to do means plus function claiming, use the word means for. I mean, that's not. I've never thought that that's particularly difficult, but you will see lots of cases turn on the fact that somebody didn't actually say in the claim that this is a means for turning a screw, or whatever the function is going to be. And if you use that language, then it is a rebuttable presumption. In fact, and in practice, it is an irrebuttable presumption, because if you say means for turning a screw, that's going to be treated under 112F. That's, you know, simply don't use other language. And
right, don't go there unless you want to go there.
Yeah. And you set out, and the other part of it is function. It's a means for a function. I mean, because what the law is going to look at under this language is, are you saying means, and does the phrase recite a generic device for producing a function, or does it recite an actual functioning object? So if you really recite a receiver, you're not going to be covered by means plus function. If you recite a means for receiving and extracting information from an electromagnetic wave, then you're going to be treated under means plus function language. So, you know, you've got to be careful to use the right language, but it's pretty easy. And once you do that, you're going to fit into means plus function language, and you're going to get the advantage of having in effect brought in doctrine of equivalence sort of breadth to your claims that you're not going to get otherwise.
See, and that's the point. You know, so many people say, oh, don't use means claims, just stay away from them, they're bad, they're evil. There's only one patent attorney that I know who ever was told, write as many claims as you can and file them. And it was with one client one time. And it was back during the e-commerce boom, you know. And so all the rest of us, and even him in every other case he's ever filed, has had to pick and choose what claims you can write and file. And that leaves all kinds of stuff open in the specification that is not being claimed. And means plus function is limited. I understand that. But it is limited to everything that is disclosed in the specification. So if you're not going to have the money to file a claim that covers everything you've disclosed in the specification, why not have at least one means claim that covers all the stuff that you're not claiming and don't have the money to claim, and get the scope, or at least try and get the scope that you can. Now, I'm not saying have every one of your claims be, or have your broadest independent claim include means language, but using this as a tool. I mean, I did try and describe it as like a heavy garlic. A little bit is going to go a very long way. And then the other thing, too, is sometimes as prosecutors, I think we fail to think about what litigators want. So one of the other things that I do a lot of times when I try and I've started increasingly doing this, is some of the patent litigators I talk to, and I say, because they tell me, you know, by the time that they see these patents and these cases, there's nothing that they can really do about it. You know, they can offer some advice if there's some families open and continuations open and stuff, but a lot of the times, you know, it's so many years later, and things are closed, and there's, you know, not a lot that they can really do. Like, what advice would you give if you could give the advice at the front end? And time and time again, I get patent litigators telling me they want to see means claims. Now, for a prosecutor, you might say, well, that's just stupid advice. But remember, one of the things that gets cases to settle is uncertainty. When there's uncertainty on both sides of the equation, then both parties have a reason to settle because they don't want to figure out the certainty. Once there's certainty in a litigation, then it becomes much more difficult to settle because one side has to capitulate. Now, if the certainty is so overwhelming, then capitulation becomes, you know, the way to go for that one side. But cases settle when there's uncertainty. Means plus function claims can add a great amount of uncertainty. So I think we're doing disservice when we say don't include them. Now, I get it. If you're writing software, there's an extra layer of, you know, these algorithm cases, and you got to have a lot of disclosure. But quite frankly, if you're doing software, and that's the area where I probably specialize in the most, is your specifications probably need to have that kind of level of disclosure anyway, based on where we're going, based on 101 case law anyway. So I'm not afraid to throw in a means claim here and there. So I would just not be afraid of it. Joe, do you disagree with anything I said? And please, if you do, throw me under the bus.
No, I don't. No, I don't. The one thing I would add is you can have a means plus function structure for an entire claim, or you can have a means plus function structure for an element of a claim. If you've got a claim with, you're going to claim 3 elements. One of those, 2 of those elements are very clear when you say on a particular generic term, and the other one can be, and the third element can be performed in a number of different ways. Then use a means plus function structure for that element, and then in the specification, you simply lay out all of the different ways that you can perform that function, and you're going to get all that coverage. So I really like means plus function.
Yeah. Now, we do have one comment here that makes a good point. He agreed with using all the tools in the toolbox, but did say, there probably needs to be a caution here that do remember that, means plus function, because they are so broad and they're going to bring everything in from the specification, that it does make it a little bit easier to invalidate them or have the examiner not allow them, because you are bringing in so much. So if any of the embodiments are in the prior art, that does raise a problem. So you do want to be somewhat cautious there. That's a good caveat. So maybe if you are going to use means plus function language, you want to, carve out and give special thought to how you're going to characterize the means, and both in the claim and in the specification. So that's a very good caveat there.
Yeah, you got to remember Murphy's first law of combat, which states that if the enemy is in range, so are you. Claim breadth is wonderful, but every time you broaden the claim, you are making a bigger target for possible prior art citations. So you got to be careful with that.
Right.
I suppose we ought to put a word for the sponsor in here somewhere.
Yeah. So this last slide here I just put in, this is just some information on the words and terms that are means, and some of them are not means, etc. But then, and some of you have been asking for this, and the tool that we had been mentioning is Patent Optimizer, and it really is a great tool. It lets you go through and check references, it checks, measurements and claims, and compares things, and it gives you an term analysis report, and it's a great thing to do before you file. And you can see here's a picture of how it looks at the drawings and the figures and the terms that you're using and the part names and numbers, and make sure everything matches up. And this is a great way to make sure that what you're filing is not going to have any of these unnecessary, silly, and silly probably isn't the word, let's say unnecessarily careless. And even that probably isn't the right way to say it, because, you do this long enough, and the one thing that is certain, whenever you hit file or send, whether it's on an email, whether it's on a patent application, whether it was on a report you were doing in college, as soon as you finalized it and submitted it, you're going to find that typo that was obvious, and it's probably in the first page, in the first paragraph, and you're like, oh my God, how could I have not seen that, right? So those kinds of careless mistakes that, humans, we just, we get looking at these things so closely we can't see them anymore. This is a great tool, and if it helps you save money for your client by reducing the amount of time that the examiner is spending on 112 actions or rejections, then you're going to get to resolution quicker. And so I'm a big fan of it. I think that this is a great tool, simply because everything I ever hear from examiners is, help us get away from rejecting you on 112. Joe, thoughts?
I agree. No, I agree, because, it's like anything else. It's the 112, as you well said, Gene, 112 rejections are most of the time very easily fixable by doing it, by doing it right the first time. And Patent Optimizer helps you make sure that you do that. And when you have a bunch of 112 rejections, the examiner is going to approach the entire prior art part of the examination with a bit of a bad attitude, and you don't want to.
Oh, correct. Yeah, very, very much so. Very much so. And sometimes, it can be so bad that they, with the bad attitude, they don't even know what to do with the prior art, and then you don't really get a good, fair first action. And then by the time you get up to 112, it's like, okay, now I see what you're doing here. And now, so the second action really becomes the first action, and that just becomes a mess. So if you are interested in Patent Optimizer, you can get in touch with Maria. Her contact information is there. You're all going to get a copy of the slides. You're all going to get a copy of the presentation. And if you're interested in Joe's book, you can also get that. It's Joe, you want to give a plug? What's the name of your book?
Sure. The name of the book is Rules of Patent Drafting, Guidelines from the Federal Circuit Case Law. It's available directly from LexisNexis, or it is available on Amazon. There is one feature that I will mention that that I don't believe is available anywhere else, and that is at the end of every chapter you will find a buried quote taken from pop culture, and so enjoy those. Yeah,
thanks. And the one thing, and I read a lot of these books or see a lot of them, and I talk to the authors and so forth, and in talking to Joe and getting to know Joe, and I can tell you, Joe has written this book, and if you read the book, you'll know that he's actually written the book, and he knows his cases and he knows what he's talking about, and I think it's a great reference, and you'll enjoy it. So, thank you, Joe. I really appreciate you spending the time, and thank you, LexisNexis. You've been a great sponsor for a very long time, and I appreciate that. And I hope all of you who might be in the market for the services that they provide will give them a test drive. They make this possible for me to do and bring to you for free. So thank you, LexisNexis. And look forward to having you join us for a future webinar. And I guess that's all. So enjoy the rest of your summer day, and we'll see you soon.
Thanks. Bye now.
Bye.